Hello, friends. Good morning to everyone. A soldier, when approaches to the department and asks for the disability pension, for he is out of the defense forces and he is a permanently medically unfit person at the time when he came out. So, usually, what happens when that soldier approaches the department denies. On what ground? There is one term that we in the courts, we means I as a lawyer in the courts, and in the letters of department also you will find that term for denial is NANA, NANA. Its full form is neither attributable nor aggravated by the department. So if there is any disability when the soldier is coming out of the armed forces, that disability usually is disclaimed by the department. Means department will say that I am not responsible for it. This disability which the soldier is suffering from is not attributable to the department nor aggravated by the department. Attributable, if I explain it little more, that department is not the cause for its occurrence. डिपार्टमेंट की वजह से ये डिसेबिलिटी इस सोल्जर में नहीं आई है, दैट इज एट्रीब्यूटेबल. Aggravated means even if the cause of disability in that soldier is something outside the department, then the department has not aggravated it. मतलब यदि कोई डिसेबिलिटी किसी सोल्जर में हुई है, कोई डिजीज, कोई ऐसा डिफेक्ट मान लो बॉडी में, फॉर दैट रीजन दैट पर्सन इज आउट, दैट डिजीज और दैट डिसेबिलिटी इज नॉट एग्रेवेटेड, मतलब होने के बाद उसकी स्थिति और नहीं बिगड़ी है ड्यू टू द डिपार्टमेंट उसका रीजन नहीं है. सो दिस इज हाउ department denies, saying that it is a NANA case, neither attributable nor aggravated by the department. And usually I have seen that these cases then come to the court because department simply, why department is doing so, that is also a reason. There is also a reason behind it. Department works as per the policies existing. Department works as per the command from the higher level. Now that those policies are not clear till now, and that's why these soldiers, unfortunately I would say, because nobody wants to approach the courts for their own rights, it is their compulsion, then they approach the court and court grants them disability pension. Now as per the policy, department is denying, but at the same time when you go to the court, there are very clear judgments of high courts and the honorable Supreme Court which clarify this position. Now what is the clarification or what is the law laid down by the courts? I will explain that. See, you need to understand it from beginning. When a soldier enters the armed forces, that soldier is medically examined. A doctor is writing that report that this person is medically examined. If there is any disease, it is natural that that person will not be recruited, that person will not be taken in. Usually you will find that when a person is taken in, that person is declared medically fit, and there is no disease, no disability you will find on the records at the time when that person was taken in. Now what happens? That person has served. Now when that person is coming out, that soldier is coming out, at that time also there is one medical board that will give the status of the medical condition of that person. Now what happens? Even if at the time of exit, I am saying, pre-release medical board they call it. So even if that person is suffering from any medical disability at that time, so that, and even if the doctors, the board declares that the person who is exiting, the soldier who is going out, is suffering from a permanent disability of calculated in percentage, then also on the basis that the doctor is writing, the board is giving opinion that this disability, this permanent disability, is neither attributable nor aggravated by the department, and on the basis of that note, department denies medical pension, disability pension to that soldier. Now, as I have already said, that compelled by the situation, that soldier would have no other way than to approach the court. So in this situation, the soldiers come to us, I mean to the lawyers, and then lawyers file their case usually before the Armed Forces Tribunal. Then what happens? What is the law there in the courts? Court says, and that is approved by the Honorable Supreme Court, there are clear judgments on that. Let's see, there are two medical examinations. Once when that person is coming in between, of course, when that person is serving, there are various medical examinations every year, that is different thing. But two main relevant to this disability pension are, one, when that person is entering, what are the records, what the record says at that time, whether that person, that soldier had that disability at the time when he entered the department, when he entered the force. Now next is when he is coming out, so what percentage of disability that person has when he has come out of the force. Now what the court says that it is the duty of the department to prove. What to prove? It is the duty of the department to prove that this disease, this disability was not caused by the department, or this disability is not aggravated by the department. Court says that the burden to prove that the disability is neither attributable nor aggravated by the department is on the department. Otherwise, when the person who is entering and getting medically examined and there is no note of that disability on the records of that medical examination, then usually court says that now it is very clear that when that person entered in the force, that person was fit, and you declared him fit, him or her, you declared that person fit, and based on that medical examination, that person got enrolled in the armed forces. Now when that person is coming out, of course there is disability, but it is the burden on the department to prove that disability was not caused by the department or any factor while that person was doing service, that disability is not connected to anything with the service which the soldier was performing. And usually what I have seen, that department fails to prove it. Let's have an example. A soldier is coming out from the force with a permanent disability, and that disability is high blood pressure, high BP. What I have seen in almost all the cases, department would deny disability pension to that person. On what ground? Department would say that this high blood pressure is a disability that is caused due to the faulty, the defective lifestyle of the particular soldier. But what the court says in this situation, in this case, that when a person, court says that when a soldier is coming in, and this particular soldier, when he entered the forces, he was medically examined, he was declared fit, there is no note on the medical documents when he entered in the department. I am talking about that medical. There is no note regarding the high blood pressure of that soldier. So once you are taking in a fit person, and when that particular person is going out from you, and that person is suffering from any disease, let it be high blood pressure, if it is a permanent disability, then the burden is on the department to prove that while that person was in service, this high blood pressure is caused. So department should prove it that this disability was not caused by the service or due to the factors that person was serving in the forces. Not due to that this disability has caused. It is the burden on the department, not on the soldier, to prove that it has caused by the department. Soldier will simply say, and court will simply see the two documents, one medical examination when he entered the force, another medical examination when he is going out from the force. Whatever happened in between, it will be presumed that this particular disability in between, whatever has happened, that disability is caused by the service conditions. So department, though it denies disability pension, court will approve that disability pension, and court will put that burden on the department to prove that if you are able to give some convincing reply and submit before the court that in between whatever the disability has caused, that has caused exclusively because of the acts of soldier, otherwise department would pay it. So now the law is very clear, the burden is on the department, otherwise the soldier would get the disability pension, let it be high blood pressure, let it be any other disease which are usually not seen from outside, but when that person is coming out with that disability, the department would have to, because of the orders of the court, department will have to grant disability pension to that soldier. Thank you so much.